beserta hadirin, selamat datang di internasional. Tema seminar internasional hari ini adalah Insolvency and Arbitration, Navigating the Issues with International Perspective. Acara seminar ini diselenggarakan oleh tim Presidium Pemenangan JRD, Jimmy Resa Edo, sebagai bentuk perhatian dan mendalam menjawab isu-isu di bidang hukum kepailitan. Izinkan saya Aswini Puspa untuk menjadi Master of Ceremony dalam seminar ini. Sebelumnya saya akan membacakan susunan acara pada hari ini. Acara akan dimulai dengan menyanyikan lagu Indonesia Raya dan Mas Akti, dilanjutkan dengan doa pembuka, kemudian ada welcoming speech dari pasangan calon ketua umum Akti, calon sekretaris jenderal dan calon ketua harian. Kemudian akan masuk kepada inti acara. Pembicara pertama akan ada Bapak Daniel Alfredo SHMH, CLA CLI, Associate of Indonesian Institute of Arbitrators. The second speaker will be Bapak Dr. Sahat Menurut Tua Sudabuke SHLL. Pembicara ketiga ada Bapak Dr. Hamonaka Syadan Barak SHMH, Associate of Chartered Institute of Arbitrators. Dan pembicara keempat ada Mr. Anandur Alami with honors. Acara selanjutnya akan dilanjutkan dengan sesi tanya jawab dan akan ditutup dengan kesimpulan dengan moderator dan kemudian akan foto bersama. Untuk mempersingkat, maka saya akan memulai acara. Mohon kepada seluruh hadirin dipersilakan untuk berdiri untuk menyanyikan Indonesia Raya dan Mas Akti. Selanjutnya dilanjutkan dengan Mas Akti.
Asosiasi Kurator dan Pengurus Indonesia, para kurator dan pengurus berintegritas, melanjut Pancasila dan Undang-Undang Dasar, wujudkan keadilan dan kepastian hukum berbisnis di Indonesia. Akti terus melayani dan membangun negeri. Akti kan terus berkarya untuk Indonesia. Asosiasi Kurator dan Pengurus Indonesia hadir untuk terus harukan bangsa. Menjaga kode etik juga standar profesi, menghina moral dan integritas tinggi. Kami terus melayani dan membangun negeri. Kami akan terus berkarya untuk Indonesia. Kami terus melayani dan membangun negeri. Kami akan terus berkarya untuk Indonesia. Kami terus melayani dan membangun negeri. Kami akan terus berkarya untuk Indonesia.
Hari ini dipersilakan dulu kembali. Acara selanjutnya dilanjutkan dengan doa pembukaan kepada Bapak Muhammad Fadli Zilzal Aksi 28. Dipersilakan.
Assalamualaikum warahmatullahi wabarakatuh. Selamat sore dan salam sejahtera bagi kita semua. Marilah kita berdoa dengan khusyuk menurut agama masing-masing, dan izinkan saya untuk memandu sesuai dengan tuntunan agama Islam. Auzubillahi minasyaitonirrajim. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin. Allahumma ya Allah, ya Tuhan kami, tiada kata dan rasa yang pantas kami aturkan kepadamu pada sore ini selain syukur kami kepadamu atas segala nikmat dan hidayah yang Engkau anugerahkan kepada kami, sehingga kami dapat hadir bersama mengikuti rangkaian seminar insolvency dan arbitration. Untuk itu ya Allah, ya Rahman, ya Karim, jadikanlah acara kami ini sebagai acara yang Engkau ridhoi, yang membawa barokah, rahmat, taufik dan hidayah-Mu buat kami semua. Ya Allah, Zat yang Maha Kuasa, kami menyadari bahwa tugas kami dalam menjalankan profesi adalah amanah. Oleh karena itu ya Allah, tumbuhkan pada kami integritas yang baik dalam setiap pelaksanaan tugas. Berikanlah kami kesehatan, kekuatan dan kemampuan sehingga kami mampu mengemban tugas dan tanggung jawab yang diberikan kepada kami untuk menjaga nama baik profesi dan organisasi kami. Ya Hafiz, ya Majid, Engkau yang Maha Pemelihara dan Maha Mulia, satukanlah hati kami, padukanlah kami, tumbuhkanlah rasa persaudaraan yang tulus dan ikhlas dalam mendukung JRE Bang Jimmy Reza Edo untuk menjadi pemimpin aktif yang bijaksana, amanah, dan melayani, dan tentunya menjadi pemimpin aktif lebih baik untuk periode yang akan datang. Berkayalah jiwa kami dalam kesucian, serta hiasilah akhlak kami dengan keteladanan. Ya Allah, Tuhan yang Maha Pengampun, Engkau Maha mengetahui terhadap kelemahan-kelemahan kami, terhadap kekurangan-kekurangan kami. Maka dari itu, kepadamu-lah kami menyembah dan kepadamu-lah kami memohon ampun dan pertolongan, serta hanya kepadamu kami melakukan pengabdian. Ya Allah, kabulkanlah doa permohonan kami. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina azabannar. Walhamdulillahirabbil alamin. Amin amin ya rabbal alamin. Wassalamualaikum warahmatullahi wabarakatuh.
Terima kasih. Selanjutnya akan disampaikan zaman speech dari pasangan calon Ketua Umum AKTI, Bapak Jimmy Semangat dan Bapak Islam. Bersama Bapak Ibu.
Selamat siang, Assalamualaikum warahmatullahi wabarakatuh. Terima kasih dan suatu hal yang sangat menyenangkan, menggembirakan buat kita semua, ya, terlebih khusus kepada kami untuk kehadiran dari teman-teman dan Bapak Ibu sekalian. Tentu di waktu yang berharga masih menyempatkan hadir dan untuk bisa mengikuti seminar ini adalah bagi kami adalah suatu penghargaan yang luar biasa. Hal seperti inilah yang mungkin akan menjadi contoh ketika nanti JRE yang diberikan amanah untuk membawa AKPI dalam periode berikutnya, maka AKPI harus melakukan hal-hal seperti ini yang diperlukan oleh anggota di dalam melengkapi kebutuhannya menjalankan fungsi tugasnya sebagai kurator dan pengurus. Kita yakin bahwa ke depan akan banyak hal yang kita bisa lakukan bersama. Terlebih khusus kepada para pembicara yang luar biasa, berada kami Daniel Alfredo, Dr. Sahat Sidabuke, Dr. Syahdan, Monang Barat, especially for my brother, Mr. Adlan Nur. Thank you very much to have you as a speaker here. I think what your presentation is very good, important insight for us to do our things, our duties as a kurator. Sekali lagi, Bapak Ibu sekalian, sahabat-sahabat sekalian, mari kita menikmati acara ini dan gunakan waktu ini untuk bisa berdiskusi dan bertukar pikiran dengan para pembicara yang luar biasa. Dan secara khusus saya juga harus berterima kasih kepada sista saya yang luar biasa nanti akan memimpin jalannya acara ini. Mudah-mudahan Sister Nancy yang luar biasa, ya, kita nikmati dan selamat berseminar untuk kita semua. Selamat siang. Wassalamualaikum warahmatullahi wabarakatuh.
Ya, terima kasih Bapak JRE, Bapak Jimmy Reza dan Bapak Edo. Semoga dengan niat baik dan langkah nyata seperti seminar hari ini, kedepannya AKPI terus maju untuk kebaikan. AKPI for all for AKPI. Kita akan masuk ke inti acara. Seperti yang sudah saya sampaikan di awal, bahwa seluruh seminar dan sesi akan disampaikan dalam bahasa Inggris. Dan seminar akan dipandu oleh moderator, yaitu Ibu Nancy Setiawati Silalahi SHMH-LLM. Beliau adalah founding and partner Flex Ratio Partnership dan juga anggota AKPI Angkatan 24. Izinkan saya untuk membacakan CV dari Ibu Nancy. Ibu Nancy telah memiliki pengalaman lebih dari 15 tahun dalam menangani berbagai permasalahan hukum di bidang corporate law dan international dispute resolutions, baik itu melalui arbitrase maupun melalui pemilihan. Saat ini beliau merupakan General Counsel juga di satu perusahaan shipping energy dan infrastructure, termasuk juga lecturer di salah satu universitas besar di Jakarta. Kemudian Ibu Nancy juga menempuh pendidikan sarjana di Universitas Indonesia, Magister Hukum di Universitas Pelita Harapan, dan Master of Law di Tilburg University Belanda. Beliau juga aktif dalam menulis salah satunya pada Insol Technical Paper Volume 51 dengan tema Restructuring Indonesia in Practice. Without further ado, I would like to invite Ms. Nancy to take over and lead our seminars. Ms. Nancy, the stage is yours.
Thank you so much, Ms. Fini, one of the angels and rising lawyer from SNR, beautiful and talented ones. Pantesan aku nggak diterima di si homing yang tekan, kayak tahu cantik. Okay, welcome to all AKPI members and also all JRE participants. Welcome to the Hotel Sultan. Good afternoon, ladies and gentlemen. I'm Nancy Silalahi. I'm AKPI batch 22, 24 kalau nggak salah, 24. It's my pleasure and honor to serve as a moderator here. Today's seminar is very important for our role, especially. This proudly platform held by the JRA that would like to ask us discuss together regarding the intersection between the insolvency and arbitration. Let's one question back to us. Do this issue make us unhappy? Kalau di Medan saya kan, acik uluku. In Makassar saya lipok uluku. Started from the street tax and Garuda, and then modern land cases, both grappling with the cross-border creditors, and also questions when the forum comes together, the PKPU commencing, but at the same time, the international arbitration is also commencing. Which one must be superseded? Could be it done together, and so on. For many of us, whether administrator, achievers, or lawyer from the legal counsels, this situation often leaves us with a headache and no painkiller or paracetamol to that. But no worries, ladies and gentlemen. Today, with us, we are going to have our exceptional speakers, our gentlemen that could be our paracetamol to this issue. Let's recall them to it. The first one. Allow me to call Mr. Daniel Alfredo, senior partner at the Service. With more than 50 years of experience in litigation and restructuring, advised major corporations like United Tractors, PT Garuda Indonesia, Adi Guna Group in arbitration and PKPU cases. He also now serves as a honorary board member of API. I think I really love him all in the package. Morning as a lawyer, afternoon as a boxer one time, and the night he keeps sharing about the meme ID Bapak-Bapak. The first thing I don't like is Olivophobia. Sorry, going Manchester United. Welcome back, thank you for visiting us. The second one, we welcome to, this one. Our favorite one, Dr. Sahat Marulitua Sidabuke. Can we have a applause to this one? Is IP consultant. He also brings a very excellent achievement milestone and set a high standard as well. Have very academic rigor and hands-on knowledge in integrating arbitration awards into the insolvency proceeding. Hello, Bang. And the third one, I think this is everyone member ujian tulis. Dr. Hamonangan Syahdan Kabara. Offshore legal counselor and respected PKPU practitioner. Managed complex restructuring mandates with debt exceeding US $2 billion. And also served as a former head of advanced education at API. Hello, Bang. Hello. I'm also as a mentee, no exception. Welcome, please have your seat. And the last but not the least, our honorable mention speaker from Singapore, Mr. Adnan Nur. A partner at the World Partnership Singapore, an Indonesian and very once of course in Singapore, handling high-stake litigation and insolvency matters, including crypto collapse and multinational arbitration. Of course, in this seminar, his insight from the Singapore legal ecosystem will help us contrast how insolvency intersects with arbitration internationally. Okay, ladies and gentlemen, today's topic, navigating the issues with international perspective, is not just a tale. We agree on that, but a necessity. From modern land to Garuda, we see arbitration clauses tested during insolvency. Who represents who? Which awards by who? And what happens when Indonesian law clashes into the arbitration process? To kick things off, let us hear from someone who has long been a crossroads insolvency and an ideal candidate for Ketua Harian API. Asik. Walk with us through the legal fiction and sometimes confusion between arbitration clauses and PKPU. Pak Daniel, the floor is yours, please.
Thank you, sis. Terima kasih Tuan Ade. Benar-benar it's truly an honor for me to share this stage with this my sister and also this distinguished gentleman. Perhaps I think that most of you don't know that
apart from brothers, we also have a family relationship. Ya. You can see that Kota Barat itu dengan ganteng.
Boleh.
So today's topic is kind of hopefully will be interesting for you all. And for me, personally, it's interesting because that you see that we now live in a challenging days. We see the evolution of legal and law every day, and we see that as now is a kind of common thing to hear that what not just insolvency, but cross-border insolvency. That's why today we also have the honor, the presence of my dear as well, that your Lord. So I think kind of go back and forth, between English and Indonesia. So dia buat lebih simpel. Ya, kira kan, ya kita tahu ya nanti share juga bisa bahan juga bisa dibagi ke teman-teman semua. Hari ini kita sebetulnya belajar sama-sama. Saat ini mungkin kami yang berempat ada di sini. Ini kesempatan juga teman-teman yang bisa sharing. Ada kami juga. Ya kita sudah lihat bahwa saat ini ya, di dunia bisnis banyak yang sudah melihat bahwa arbitrase itu sebagai salah satu cara untuk menyelesaikan dispute, forum menyelesaikan dispute. Tidak cuma di Indonesia, tapi juga di dunia internasional. Dan juga tidak cuma arbitrase, kita juga sudah semakin banyak melihat proses kepilitan juga sebagai salah satu forum yang dipakai dalam penyelesaian dispute. Walaupun mungkin saya juga bisa dalam dispute ya. Dan ternyata ada banyak persinggungan yang terjadi antara kepilitan dan arbitrase. Kalau kita lihat sebagai kepilitan sebagai suatu sifat umum dalam suatu extraordinary court, dalam suatu sidang, dalam suatu pengadilan khusus menjaga, yang dimana tujuannya adalah untuk membekukan aset dari yang diutang kreditur supaya nggak diperbutkan oleh kreditur. Sedangkan kita lihat arbitrase itu adalah suatu extrajudicial dispute resolution, ya, di mana kita jurisdiksinya itu mungkin ada yang bilang sebagai apa ya, kalau arbitrase itu sebagai suatu parti otonom, kesepakatan para pihak. Kalau misalnya insolvensi, paling atau PKPU yang di Indonesia juga ada, itu lebih cenderung ya itu sebagai aspek publiknya sangat kencang. Gitu. Kita lihat di sini karena diatur dan undang-undang diatur oleh negara sebagai stakeholder-nya. Gitu. Nah, di kita sendiri ya tentunya diaturnya dalam Undang-Undang 37 tahun 2004. Ya, di mana di sini kita lihat bahkan dalam Undang-Undang Kepanitiaan sendiri memiliki pasal 303 dari Undang-Undang Kepanitiaan yang benar-benar bahwa pengadilan tetap memiliki kewenangan untuk memeriksa dan memutuskan untuk permohonan kepanitan walaupun dalam pihak-pihak yang berperkara tersebut terdapat klausul arbitrase selama memenuhi persyaratan dan pasal 2 ayat 1 dari Undang-Undang Kepanitiaan. Dan terdapat semacam kesinggungan dengan Undang-Undang 30 tahun 1999 tentang alternatif penyelesaian sengketa, pasal 10, di mana perjanjian arbitrase itu atau klausul arbitrase itu nggak jadi batal walaupun adanya suatu kepanitan dari suatu pihak di huruf B-nya. Gitu. Jadi sini lihat bahwa pengecualian dari klausul arbitrase di insolvency proceedings itu bertentangan dengan prinsip dari commercial exit from financial distress. Jadi ini menekankan bahwa kepanitan itu bisa digunakan sebagai suatu alat untuk perusahaan-perusahaan atau kreditur untuk overcome financial difficulties, untuk menyelesaikan apa masalah yang dihadapinya. Jadi excluding the arbitration clause make it easier to use insolvency proceedings as a tool to bankrupt a company. Nah, di pihak lain sisi lain ada poin juga bahwa ini in circumstances where underlying debt is subject to an arbitration clause, kalau utang itu ada tingkat juga klausul arbitrase, itu sebetulnya debtor itu bisa may wish to wield the arbitration as a shield, bisa gunakan klausul arbitrase tersebut untuk apa ya, menyingkirkan upaya dari permohonan kepanikan atau PKPU. Gitu. Nah, sedangkan sisi lain sebagai kreditur kita juga mungkin menggunakan proses kepanikan atau PKPU itu sebagai pedang untuk langsung potong jalan, motong goes all the way through, potong itu ada proses arbitrasenya untuk langsung nagih dan gitu, misalnya dispute. Gitu. Jadi sebagai mungkin pemahaman yang umum, arbitrase sebagai extrajudicial dispute resolution itu enggak menisbikan, enggak menghilangkan kewenangan dari pengadilan niaga untuk bertindak sebagai extraordinary court-nya, sebagai forum pengadilan yang berhak. Nah, kalau ada seorang expert yang meletak di bidang keperadilan kita hormati ya, Pak Adi Suban aja itu dibilang bahwa pendapat bahwa ada beberapa juridical reasons for the absolute authority of the commercial court. Ada benar kekuasaan absolut dari pengadilan niaga. Karena satu adalah karena si Undang-Undang 37 2004 itu sebagai suatu lex spesialis dari undang-undang arbitrase. Jadi itu berhak untuk memiliki kewenangan khusus, dan juga ya tentunya dengan itu tadi pasal 303 itu yang sebagai suatu lex posterior prerogatif priori. Di Indonesia sendiri dalam bahan yang saya siapkan ini memang banyak terjadi ketidakkonsistensian terkait dalam adanya perbenturan antara klausul arbitrase dengan kepanikan. Contohnya putusan nomor 706 K dari PDPSUS yang KLS 2025, di mana yang di situ diputuskan di mana bahwa pengadilan niaga itu nggak punya kompetensi untuk memeriksa perkara dispute antara pihak karena adanya klausul arbitrase di perjanjiannya, dan juga adanya juga putusan yang 012 K dan N dari 1999 di mana bahwa adanya dari otoritas di arbitrase itu dari fakta subsidiarnya itu nggak bisa menghilangkan kewenangan khusus extraordinary yang ada di pengadilan niaga terkait dengan permohonan dan PKPU. Nah, kalau untuk dengan kaitan dengan asing, what if choice of arbitration as a foreign institution? Nah, ini juga ada tantangan-tantangan yang sampai saat ini kita ini belum mengadopsi, belum mengesahkan untuk sinetral itu ada model law atau model insolvensinya. Jadi itu juga kita melihat bahwa terdapat banyak tantangan untuk mengeksekusi putusan arbitrase asing di Indonesia dan digunakan sebagai dasar untuk permohonan balik atau PKPU. Jadi bisa kita nanti bisa diskusikan bersama beberapa putusan-putusan yang dari saya bilang adanya inkonsistensi tersebut. Nah, tapi paling yang akhirnya saya bisa bilang bahwa it should be noted that regardless of the applicable law, the Supreme Court of Indonesia has started to implement the principle of commercial acts from financial distress. whereas the bankruptcy should be avoided for solvable and viable companies. Although apparently in civil law system, the Supreme Court is allowed to make precedents and apply judgment law. Jadi memang kita kan hakim seorang undang-undang dan bisa membuat putusan sendiri. Yang perlu kita perhatikan adalah masalah konsistensinya. Ya mungkin dari saya bisa di-share sama itu.
Okay, thank you, Mr. Daniel, for highlighting us regarding the arbitration clause and the insolvency proceeding that can legally collide, whether the precedent also, jurisprudence also looks like keep the tension sharing out continuous. Next, to deepen our understanding, especially in terms of how arbitral awards can serve as valid evidence in restructuring proceeding, we now turn to Dr. Sahat Sidabukir. His expertise will briefly reflect an evidentiary value on his presentation. Mr. Sahat, the stage is yours.
Okay, thank you very much for your kind gesture to me before. Before I start my presentation, allow me to say our greetings as well to one of our senior, one of our teacher, Dr. Ricardo Simanjuta, which is now. Thank you very much. And also, well, I'm kind of nervous actually over here. A lot of people in here who also my teacher, my colleagues, my friend. If I may, before I start my presentation, maybe like we can bring our cheer up a little bit. When I say I am happy for all, and you know, how do you explain that? Happy for all? All happy. Thank you. Yeah. Well. Well, in here, right now, there's one question that Mr. Nancy actually also want to bring some subjects to me. Well, talking about the role of arbitral awards in Indonesia restructuring and bankruptcy proceedings, and I'm looking at the enforcement challenges and also in the legal effects. So, as Mr. Alfredo also just mentioned before, we see the context in here. We understand that the law number 30 of 1999 on arbitration and RBR, we know and see that people who have have some problem or have some matters, they allow for the parties to resolve the dispute outside the court. The arbitral award also can be a part of them, to bring and to creating some solution regarding for that. It's either in the international awards or even in the domestic award that both of the parties or agree in their clause for the agreement that they already made. However, in this part, we know that the bankruptcy is also one of the solutions for the part to when the part will have a lot of debts buying with each other. They also try to use the suspension of their payments, either come from the creditor itself or also voluntarily by the debtors. This is also a kind of thing that people in Indonesia also try to do it here. So that's why in here, when we see both of this regulation that right now is also regulated in Indonesia, this is a kind of thing that some part we see that this is a good thing, but some part, especially for us as an administrator and also the receiver over here, we also see there's also some challenge when we do it and when we go to this part. Next slide. As we understand, when we see the arbitral awards as an evidence in the bankruptcy and restructuring, we see that from our application article 2 paragraph 1 in our bankruptcy law, we see that this is one of the part that we always see and we always go through when we try to proceed the bankruptcy process, which is debt which is due and collectible. Which one of the requirements and the thing that you can see that it is due and collectible is about the arbitral award. This is one of the simplest things when we try to go through the bankruptcy and the restructuring award. However, maybe I do it in the practical way. When the lawyer and when the people want to do that, to submit the bankruptcy process. They also need to know there's a requirement to do that, which is from the Article 6, Paragraph 7 from our arbitration law in Indonesia. The written agreement basis for all of the alternative dispute resolution, not only for the arbitration, they must register it in the district court, which is like in the Jakarta. So, well, I mean, like for some people in here, maybe like if you're not like you're not choose by people in here like to become the creditor, or, sorry, for the administrator or receiver. This is like one of the things that all of the parties must understand. Don't forget to register it in the district court. Next. So, as for the international arbitral award, we're not only also like I said that, oh, is it I mean like is it like directly or like a no-need or something? By the law in the Indonesia, they also already been covered in our Indonesian law, which is in here the New York Convention, which is like the recognition of the enforcement of the foreign arbitral awards. We also already been ratified that in our presidential decree, number 34, 1981, which is before or like maybe like right after the changing of our arbitration regulation. So from this part, we see that like our regulation is also already continue and then like try to understand not only the national part but also in the international part. We also like try to our government also already see that this is like also the kind of thing that we need also to rule and also to govern together, because like Indonesia, we're not only like doing this only in the national part, but we know that we see that like there's a lot of investors from foreign countries, from the foreign companies who also come to Indonesia, and then most of the agreement which for like before this event, I did like some talk also with Mr. Anand. They also like put some clause related with the arbitration inside the agreement. So that's why like here we see that like our government also already see that, which is in here like when we try like to when we go to back to our presentation before, when we try like to register the court, the central court, they will not, I mean, they not see the context of the award itself. But they only see the formalities, whether this is already being made in the I mean, like regulated by the government itself. Or like, so they only see the formalities. They don't see the context inside the award. So that's why like when we see the Article 2, Paragraph 1 from the bankruptcy law, we can see that this is like how simple is that, like when we put the international arbitral award itself to become like one of the evidence when we try to submit for the bankruptcy or the PKPU process. We know that the arbitral award is a final and binding. We also already see that, I mean, like most of the professional over here also already understand that this is a final and binding. However, when we go through from our bankruptcy law, we face another challenge again. We see this is final and binding, but we cannot enforce it. When the parties already goes to bankrupt, still back. Okay, same thing. So there will be an impact. So even though like we already received the arbitral award, which is already final and binding, we cannot enforce it when the parties already goes to the bankrupt or go to the PKPU process when the award already been made by the commercial court in Indonesia. So we stay. They cannot do the enforce for things that they already bring in the arbitral award. Next slide. So in here from the Article 24, the debtors shall by law forfeit their right to control and manage their property, which is already included in the bankruptcy property, from the date the decision on bankruptcy declaration is rendered. So from this part, nobody can touch it, all stay, don't do anything, even like you already win the case in the arbitral award, national, internationally, can't do that. So this is like the effect, this is the challenge. When the people already do the arbitration, they say like, oh, how do you win this part? But back to our bankruptcy law, which is like in here, there's like a one senior who mentioned to me that like when you go to the bankruptcy law, just see the bankruptcy case. When you go to the arbitration, go to the arbitration. This is like a support that like always I mean like we always put it and like always go through when like we do this kind of part. So for the bankruptcy law, all state from the behavior suspension of their payment obligation, the creditor also shall participate in the creditor's meeting, which is in here. Like if one of the parties already made the arbitral award, they also must or shall become the creditor, which is in here. They're the creditor who also doesn't have the collateral, both the part in the collateral, even they already have the awards, but that's not the collateral as I mentioned in our regulation. That's why. So for the challenges to the arbitral award, we also understand that when is it already final and binding, our bankruptcy law also still giving some chance to the party to do some kind of the legal action. This is also like one of the challenges that might happen for the parties who already made the arbitral award. So this kind of a challenge, if the award obtained through the fraud, as I mentioned in the Article 73 from the bankruptcy law, arbitration law, there are like the three parts in here, as I mentioned in my slide. You can see here. So it's like when we go there, and then like for example, in here, if the receiver or the administration also see that if there's a fraud in the award, the receiver and the administration also can try and like can do the legal action regarding for them. We know that like the receiver and the administrator in here, they have the philosophy to to try to take care of all of the process of the bankruptcy over here and like to all of the creditors, not only for some part. So that's why like they always like see in the big way and like in this all of the not only like one for the some part. So this is like the kind of the challenge that might happen during the process, even like you already have the arbitral award. Next. So again, for the conclusion for my part, the arbitral awards are valid evidence, but subject to the bankruptcy stays. The international arbitral award also will require the executor, which is like also to register itself again in the Central District Court in Indonesia. The bankruptcy prevails over individual enforcement. And the last one, the arbitral award can be challenged if fraudulent. Well, later, see like there's some in here. Well, the topic like will be great later. If we see the Indonesian regime, we be like great. I mean like when we see the Singaporean regime, how are we gonna do that? How are we gonna supposed to process all of these things? Thank you very much. That's for all. Thank you very much for all.
Thank you very much, Dr. Sahad. Okay, ladies and gentlemen, Mr. Sahad just laying out that yes, the arbitration clause can be used for the insolvency proceedings, but not without the challenge. So the challenge is on the table. That's expected that from your knowledge, your experience knows how to overcome. Okay, next. As we have talked and discussed about regarding the arbitration clause, the insolvency proceeding, we would like to also explore how the capacity to act in arbitration could shift to the receiver and what this means for authority and representation during cross-border proceeding. This session will be hosted and presented by everyone mentor for ujian tulis, Dr. Syahdan.
Masih semangat ya semuanya ya?
Masih ya?
Happy for all?
Oh, for happy.
Okay, as you noticed from the very impactful and delightful presentation from all of these distinguished gentlemen sitting right next to me, that you will notice there are several redundancies that I will have in my slides compared to these both gentlemen, because it is very important for us to emphasize to all of you distinguished attendees that the arbitration and the bankruptcy law does not supersede one another. They were not meant to remove or eradicate each other's authority, because each of them serve different purposes. Next slide. One of my professors said, if you were having arguments about the law, you have to come back to the philosophy. So henceforth, I'm bringing the philosophy of both arbitration and bankruptcy here. See, as you can see, I do not need to read you the whole text. I will emphasize the one in bold and underlined. That arbitration is the resolution to disputes. Okay, it's based on contractual agreement between parties that have agreed that they will appoint arbitration forum as they forum to settle their disputes. And the purpose of arbitration is resolution to dispute. So if you notice for resolution to dispute, there is still a word dispute there. There is no fixed claim or amount that needs to be paid by the respondent, for example, if you are the claimant. So at the moment the arbitration is initiated, no parties have the fixed amount on how much you should pay and when and where, or the mechanism of the payment, because it's still being disputed. Okay? While the bankruptcy is the ultimum remedium, there is no longer dispute or no longer debate on the amount of the claim. That's why if you're filing a bankruptcy or PKP, as Dr. Saad and Pak Daniel Alfredo explained, you need to have a very simple manner on the evidentiary process. Because if you bring up a complicated or complex evidentiary process, it means you are still disputing the claim. You're following me so far? So jumlahnya utang di dalam PKP lepas itu tidak lagi diperdebatkan ya teman-teman. Itu sudah harus fix. While arbitration serves its purpose to find out how much damage or claim or compensation or what have you that should be paid by the losing party. Right? So if you understand the difference between... Next slide. Okay. So the arbitration is the matter is still being disputed, while the bankruptcy, the value of the claim is fixed. It may also derive from the arbitration award. That's why if you see the article 3 from the Indonesian bankruptcy law, it doesn't mean that although you have a bankruptcy clause, although you have an arbitration clause inside your agreement, within your agreement or your contract, you can still file a dispute to the pengadilan niaga. It doesn't need to be read like that, no. It means if you have an absolute amount or fixed amount between the defendant and the plaintiff, then you can go to the commercial court, the pengadilan niaga. The fixed amount no longer being disputed. But if the case example is like this, for example, you're a contractor, a mining contractor, and then you disputed your user, your client, because your client does not pay you this amount and this amount, and that your user, your client say, oh, because you haven't finished this block, so you need to finish this first. It's still being disputed. That's why, if that's the case, which authority that you need to go? The commercial court or the arbitration? Arbitration, exactly. So that doesn't mean, oh, because Article 3 said I can go directly to the commercial court. If you're following that route, then you will have a very complicated and complex evidentiary process, and that's, of course, contradicting the principle of a simple manner in evidentiary purpose of a commercial court. You understand so far, right? So it's different. It does not supersede one another. It does not eradicate the authority of one another. It goes side by side, aligned in harmony. So we do not again discuss the difference or which supersede which, but now we understand each has its purpose. It's very important, Bapak Ibu, because I think speaking of in terms of AKPI, the battle of AKPI is no longer being number one in Indonesia or being number I don't know like. The fight is out there. Probably one of you, I think the majority of the attendees here are a licensed receiver. Probably one of you someday must represent your bankruptcy debtor in the form of arbitration, ICC, SIAC, whatever, probably but if you don't understand your position at that time, I'm not speaking about English speaking level. You can hire a lawyer that can speak like King Charles, no problem with you. I'm not talking about your English speaking skill, I'm talking about the appropriate knowledge of differentiating between arbitration and BKB or bankruptcy. I'm speaking on that level. If you fail to understand the difference between the two, and once you have the client, you have the debtor's bankruptcy debtor that you need to represent as a claimant or respondent, then you know that your quality is being tested at that stage. So I think at this level, and I can assure you, JRA can bring you to that level. I can assure you. Everyone can lead if you give them the stake. Leading is very easy. I can tell you, leading is very easy if you have the stake. But guiding you to the appropriate level, to uplift you to the level which that you can grow yourself along with the organization is a very hard thing to do, gentlemen, ladies and gentlemen. So I can assure you, choose your leader that can uplift you to that level. I think they can bring you to that level.
Can you give a biggest applause for that important point from the presentation?
Okay. I'm not paid for that. This is coming from my heart. Okay, this one. So next slide, please. So if you read our bankruptcy law, it was designed to adhere to universality principle of Indonesia of the law. You can read Article 21. You switch next slide, please. Article 21 said that bankruptcy covers all assets of the debtors. Yeah, you have the right one previously. Okay. Bankruptcy covers all assets of the debtor. It doesn't say specifically in the area or in the territory of Indonesia. No, it was meant to be universal. Wherever the assets might be, right? So you see what's right in front of you. You are facing the world today, ladies and gentlemen. You're not staying in Jakarta, Makassar, Semarang, Surabaya, no. Your assets, your debtors assets will be in Panama, Mexico, what have you. And once it's disputed right there in any other form of arbitration, you should be ready. Okay, next. Now, this is what we call the assignment of authority in the bankruptcy law. First, of course, without any bankruptcy or whatsoever, I think it's easier for me to see this. The right to manage the debtor's assets is solely on the debtor's right? The company's right. But once the bankruptcy decision is being awarded, then there is an assignment. Because Article 24, Paragraph 1 of the Indonesian Bankruptcy Law elaborates that the debtors lose its right to control or to manage his bankruptcy estate, harta piling sekarang namanya. Yeah? And then assigned to who? Article 69 said it's assigned to the receiver, because the receiver is responsible for managing or settling debtor's bankruptcy estate. Okay? Now coming from this Article 69 comes the next article. Okay, next. Article 26 says claims or lawsuits, so arbitration claim falls under this category, right? Claims or lawsuit concerning rights or obligation. Rights, it means you are claiming something that belongs to you. You means you are as a receiver, right? Obligation, it means someone else is filing a claim against you that you need to owe or to pay somebody. Involving the bankruptcy shall be filed by or against the receiver. So you can be either the claimant or you can be either the respondent in the bankruptcy, in the arbitration case. And as you can see, arbitration dispute is a contractual dispute, and the outcome of the award will be either damage that you should pay, right, if you are the respondent, or compensation, or the combination of the two. They both are matters related to rights or obligations involving the bankruptcy. So The big question in the case of arbitration, can you represent you as a receiver? Can you represent the debtor as a claimant or as a respondent in the arbitration law, in arbitration forum? Yes, of course. It's fully your right. You can represent them. Okay, next. Now, in the arbitration, parties are generally free to choose. The substantive law governing the contract dispute, for example, let's agree this Indonesian law. And then the procedural law tied to the seat of arbitration, you can choose the forum is SIAC or ICC or Hong Kong arbitration. By the way, SIAC. And the law governing the arbitration. I'm not going through the number 2 and number 3, I'm going through the number 1. So if the substantive law is, Indonesian law is chosen as the law that governs the contract, it means Indonesian law, including the bankruptcy law, is in there as well. So if the bankruptcy law regulates the Article 24, paragraph 1, Article 69, paragraph 1, and then Article 26, paragraph 1, it means you, as the curator, as the receiver, you have the full right to represent the debtor's asset in the arbitration forum. We have the proper understanding here. So there is no one that can say you are not authorized. No, you are authorized by the law. Okay? Next. So I'm giving you the example of the clause. I think everyone should have read this by now in 1 or 2 contracts. Next. Okay, so what if the chosen law is not Indonesian law, for example, English law? Okay. There is a basic principle of the capacity to represent parties. I think in most forums, arbitration or district court, if you represent a party, first, the very basic principle is to check whether you are the person authorized to represent or you have the capacity to represent the party or not. Yes? That's the very basic principle. So at that very same moment, let's say the English law is chosen and then the Indonesian parties appear before the tribunal forum, and then you will be asked whether you are authorized to represent. You as the receiver, what then you bring? The bankruptcy decision, which gives you the right to represent. Because coming back to the capacity to represent, it all comes back to your own national law. If you are from Mexico, then you have to prove that you have the right to represent this party according to Mexican law, because that's where the company is being established. Okay, next. See, the POA, Board of Resolution, Madam Letter, court decision that mandates the authority. So bankruptcy decision falls under that category. Arbitrators may reject files or arguments made by a person without verified authority. So if, say, the director of a bankrupted debtor force his way or her way inside the tribunal forum and say, no, Indonesian law doesn't apply here. Siapa itu kurator, gitu ya? Saya dirut, saya tetap ngotot di sini. The arbitrators will check. Oh, sir, sorry, you are in bankruptcy status, so you do not have the right to represent here because you have lost the right to manage the bankruptcy estate. And ladies and gentlemen, the understanding of losing the right to manage the bankruptcy estate is pretty much the same all over the world. Is that right? In bankruptcy, you're losing the right, the director is losing the right to manage. I think it's pretty much the same. So the basic knowledge is the same. Okay, next. I'm afraid I'm not good. So the capacity is national of such party. So the final verdict, receiver is authorized to represent the bankruptcy debtor to act as claimant or respondent in the arbitration court. Next. Now, would the final arbitral award impact the execution of assets under insolvency? Next. Article 27.1, paragraph 1, Indonesian bankruptcy law. Any claim filed for the fulfillment of contractual obligation, remember the keyword of arbitration is contractual disputes. The outcome will be a sentence or an award related to a contractual obligations. Okay, this is the relation between those two. Against a bankruptcy that arises during the bankruptcy period. So if the arbitration award is given during the bankruptcy period, right? Can only be brought by registering the claim for verification. Jadi misalnya Bapak Ibu nih pertengahan lagi kepailitan, ada putusan arbitrase yang sudah final and binding, mengikat, and then bagaimana nih hubungannya dengan sita umum yang sedang jalan? Itu bisa didaftarkan ke kurator, Bapak Ibu. Jadi kalau nanti Bapak Ibu jadi kurator, if someday you are a receiver and you receive a claim in the form of arbitration award, do not say, oh, I do not acknowledge this, go out. No, you can receive that. You can check, verify, and then it falls under the same category as final and binding decisions in Indonesia. Kayak putusan ingkrah ya. Jadi jangan ditolak dengan arbitration award bahasa Cina, bahasa Meksiko, bahasa Spanyol langsung tolak. Jangan dulu ya. Ya karena itu bisa dibuat sebagai pendaftaran tagihan. Hanya bisa ditagihkan dengan mendaftarkan. Ya, dia tidak bisa lagi langsung eksekusi karena sudah terjadi sita umum. Hanya bisa diperoleh pembayaran dengan mendaftarkan. Next. Okay, this is the following order. So the arbitral award and then the motion for executorial. Still, okay, and then filing the claim to the bankruptcy receiver, and then receive pari passu payment subsequent to the sale of bankruptcy estate. Jadi habis pemberesan baru terima dan pasti konkuren ya, Bapak Ibu ya, karena namanya putusan dan jaminannya gitu ya, pasti konkuren. Next. Okay, I think that's my 3 cents from my share to you, and the most interesting one will be my colleague is Adnan. Thank you. Sorry kalau ada salah kata. Happy for all.
Thank you so much for the very great extension and time, Bang Syahkan. Thank you for also clarifying the position of the receiver should be very firm in the beginning regarding the arbitration and the insolvency proceeding. Thank you for also sorting out what philosophical foundation that shape for favor. To broaden our lives, now we welcome Mr. Adnan Nur. Will share insights on how Singapore handles the overlap between the arbitration and insolvency, and what Indonesia can learn, especially on cross-border safeguard and cross-border regulation. Mr. Nur, the floor is yours. Thank you.
A very good afternoon. My name is Adnan from Singapore. While on paper I might be a foreign guest, I like to think of myself as a local because I've been coming in and out of Jakarta for the past 2 to 3 years. And if you cannot find me in Roma, you can find me in the Sederhana along Daniel, which is my separate office. I'm always happy to be here and to speak at such events together with old friends and make new ones. I have been asked to share a bit about the overlap between insolvency and arbitration from a Singapore perspective. And I was telling my friends earlier that the timing of this event is very good because the Singapore court has recently issued 3 decisions that deal with this overlap. I have an article on each of these cases and I will pass it on to the organizers to share with the attendees here. What I will try to do is tackle the overlap between insolvency and arbitration at different stages of a proceeding. The very first one, of course, is what do you do when you have a claim in a contract that has an arbitration agreement before a company is put into liquidation. So, to steal some language used earlier by Pak, this is when the creditor can use insolvency as a sword, because the temptation will be to go to the Singapore court directly to petition for winding up and go around the arbitration agreement. So this is when the creditor uses insolvency as a sword. The Singapore court has clarified this cannot be done in a situation where the debt is disputed. So I think earlier, Mark, you had mentioned that simple evidence, yeah? If the evidence is not simple, it means the debt is disputed. Similar concept in Singapore. If the debt is disputed and subject to an arbitration agreement, you have to go for arbitration. And this is underpinned by Singapore's policy, which is pro-arbitration. In Singapore, it is very easy to bring a challenge to an award, but very difficult to succeed. I think the numbers are every 5 applications, only 1 is successful. Singapore is very pro arbitration. So now that we have covered this example, we now move on to the next one, which is you have an arbitration and then the company goes into insolvency. So in Singapore, we have this term called moratorium. I think in Indonesia, it's called bankruptcy stay, which was explained earlier by Pak. What this means is that any Singapore court proceedings must stop. As for arbitration, if the arbitration is seated in Singapore, then it must also stop. You will have to go to court to get permission to continue. Now, of course, what if we are in a situation where one of you have a Bali arbitration seated in Indonesia, but the counterparty in Singapore becomes insolvent? Because the arbitration is in a foreign seat, technically it can continue. But then comes the commercial thought process, which is if I finish the arbitration and then I go to Singapore to enforce it, do I have a paper judgment? Because I think similar to the slide that you shown earlier, yes, you will have an award with money, but you will only get paid pari passu. So a lot of times, what we advocate for is instead of spending the money to finish the arbitration, go to the liquidators, which is the equivalent to the administrators here, have a settlement. Shake hands, maybe you settle 40 cents on the dollar, but still, you save time, you save money, and you can participate as a director. I mean, it's less money for the lawyers, but it's a better outcome for the clients. In fact, right now I'm dealing with this same exact situation in a Singapore liquidation, where there is an English-seated arbitration, which we cannot settle, which we cannot stop, unless we go to England and go to the English courts. But who wants to spend that money? So, as we speak, just earlier today, I got a call to try and settle that arbitration, and then let them participate in the liquidation as a creditor. The game is a bit different when the proceedings are not insolvency proceedings, but they're what we call in Singapore restructuring proceedings, similar to the PKPU, where the plan is to get a composition plan. Yeah. The good thing about Singapore is that we don't have the 270 days time limit, right? Well, I mean, usually you can drag it out through the Singapore courts, although now they're getting a bit tighter. So what a lot of people don't know, from my experience, the Indonesian courts are a bit more strict when it comes to timelines than the Singapore courts. Yeah. But now, of course, let's say if one of us goes to Singapore for restructuring, you potentially have an arbitration claim. What do? Because again, when you start the restructuring in the Singapore court, there is the stay or the moratorium. The Singapore courts have clarified that you can carve out the arbitration from the moratorium. This is allowed under Singapore law. But you must convince the Singapore court why that should be the case. The Singapore court will look at the complexity of the claim and whether there's any prejudice to the other creditors. So if you want to succeed in such an application, my strategy would be, you tell the Singapore court, this claim is so complex that if it goes before the administrator, he or she will not want to determine the claim. And next thing, you must show that there will not be any prejudice to the other creditors. And if you can convince that, then you can carve your way out of it. So this happened recently. There is a Malaysia restructuring of a company called Sapura that has got subsidiaries in Singapore. Same thing in the High Court. The High Court granted a carve-out, and the Court of Appeal upheld it. And the Court of Appeal was very specific in clarifying the policy difference between liquidation and restructuring. Because in liquidation, you don't want there to be an abuse of process where creditors use insolvency as a sword. But in restructuring, the policy is what? Time and space. What we say, breathing room. The company has to have the breathing room to rehabilitate itself. But of course, we must also protect party autonomy in commencing arbitration. So this is where the balance lies. So if you ever want to go to Singapore courts, you cannot go there and say this is in my best interest to have arbitration. You must say actually it's good for the other creditors, because if we go for arbitration, we can finish it faster. It's quite complex and it will not affect the deal that is being done now. But another interesting point, at the High Court level, when the company was successful in coming out of arbitration, before the Court of Appeal hearing, parties had a settlement. They had a settlement. I think they agreed to a sum, and then they proceeded from there. So that generally covers the different scenarios that we're dealing with. What I wanted to discuss a bit is insolvency, arbitration being used by debtors in an insolvency. In fact, that has happened recently. There is an Indian cryptocurrency company called WiserX, WAIZERX. What happened is a hacker stole $200 million from the company. So now they're trying to do a scheme. And one of the pressure points that the company uses to pass the scheme is that there could be potential arbitration with another company called Binance. You might be familiar with it. So the threat of the arbitration was used as a pressure point to get the users to agree to the deal. So they will say things like, oh, if we go into liquidation and the arbitration starts, you will only get your money back in 7 years. So might as well you agree to the deal now, so that you can get your money back, maybe 40, 50 cents on the dollar, but you get it faster. So it's interesting to see how it can be a sword both by the debtors and the creditors, depending on how we want to approach it. At the end of the day, Singapore is an arbitration hub. Singapore is also now trying to become an insolvency hub. The SICC wants cross-border restructuring to come over, and we've seen the recent Garuda case as a successful one. The balance between the two regimes is quite delicate, because Singapore doesn't want to make it seem like it prefers one over the other. But fundamentally what we're seeing is that if you do have an arbitration, generally you have to comply with it and not supersede it. But at the same time, you can go to court to get permission to carve yourself out of any bankruptcy state that the court has. So I think with that, I have generally covered the points I wanted to make, and I'm happy to questions from you. Okay. Thank you very much.
Okay, thank you so much, Rahmat. This is applause to the gentleman. Bapak Ibu, ladies and gentlemen, we are now open to the floor. If there is anyone of you who would like to raise your hand regarding any question you would like to ask directly to one of these gentlemen, please feel free. Meanwhile, we also have collected as well some question from the participant during the registration. Ada yang mau bertanya mungkin? Feel free to ask in bahasa, in English, bahasa Batak juga boleh. Boleh sahabat kita tuh foto. Bahasa Makassar ada kita Pak Reza, Mas Majid. Ada mungkin from the floor regarding the arbitration, insolvency. Mumpung nih ada expertnya. While we are waiting for the floor, I think we will try to read one of the questions that we have collected. Okay, from Johannes Gea. Bang Johannes? Here or nothing? Oke, kita bawain aja ya. Johannes Gea, API 29. So, he asking about the implementation of arbitration awards to bankruptcy petition and practice. I think the question will be directed to Bang Daniel. So the question as follows. In practice, how can arbitration award be used firmly as a basis for a filing bankruptcy petition under Indonesian law? For example, if the company has been ordered to pay a debt under a SIAP arbitration award, but fails to do so, the company fails to complete it or to follow the award, can the award be simply used as a valid proof of debt and default to initiate a bankruptcy process under the Indonesia Commercial Code? Do you think that only administration arbitration could be accepted as a simply manner basis to file the bankruptcy petition? How if, and simultaneously, the challenge to the arbitration award for us also commencing as well? That's the question. Thank you, Johannes Pia from SDG Lover.
Dijawab satu-satu dalam bahasa Indonesia apa ya? Oke.
It's okay banget bang.
Mungkin yang dari yang balik kayak saya bilang, kita balik filosofi dasarnya aja. Putusan arbitrase baik nasional maupun internasional itu sendiri, kalau menurut pendapat saya sudah merupakan suatu apa ya, kita bisa bilang suatu atau otentik, sudah sebagai bukti kuat bikin apa adanya suatu kewajiban yang harus dibayar oleh satu pihak. Setidaknya dalam hal itu sendiri itu sudah memenuhi prinsip pembuktian sederhana, nggak ada dispute lagi. Nah, bagaimana implementasinya nih? Kalau tadi seperti dalam kesempatan kita barusan juga sempat bicara juga sama-sama. Nah, bagaimana pelaksanaannya dalam permohonan? Gitu. Kita di sini sepakat bahwa baik itu merupakan putusan arbitrase nasional maupun asing, itu kan suatu eksekuatur. Jadi nggak sederhana kita pegang putusannya terus untuk langsung jadi bukti, jadi basis. Ternyata itu nggak cukup. Gitu. Itu udah jadi dalam bahan presentasi nanti bisa dibagi teman-teman juga. Itu bahkan jadi sumber ketidakkonsistenan dalam pengadilan niaga untuk membuat putusan. Nah, kalau untuk yang asing sendiri, yang jangan ngomong siap, itu problem. Kita yang perlu kita pastikan adalah satu terdaftarkan dulu, itu sudah terdaftar putusannya, dan kemudian didapatkan putusan eksekuator. Nah, udah dapat itu jadi kayak pelengkapnya, jadi paket pelengkap buat putusan arbitrase asing tersebut untuk kemudian mengajukan permohonan pada PKPU.
Siap, udah mantap dan jelas nih bang. Jadi can we use but just ensure that already obtain that square procedural prior to.
It definitely can be used, but definitely that you need to comply with further procedures.
Oke, kopi, thank you bang Daniel. Oke, langsung ada pertanyaan. Kalau bang Kabel nanya ke ujian disertasi jadinya bang nanti. Okay, please, Bang.
Thank you for very excellent presentation from for the speakers here. And thank you, Pak, for your presentation. You have explained that the fundamental difference between the bankruptcy or insolvency and arbitration is based on the merit of the petition. When it is proved that the debt has been due and payable undisputed, then the solution of that must be a collective one. So that does not have any reason for dispute anymore to be go through arbitration. the previous question is how far is the finality of the decision of arbitration? For example, if the decision of the foreign arbitration award was brought to Indonesia as a final decision, a binding decision, how far it can go to the commercial law as a basis for petition for bankruptcy, in your experience? In our experience, because one of the requirements according to if I'm not mistaken, it's Article 125 of Singaporean Insolvency and Restructuring, right? Saying that one of the reasons is the decision of arbitration that has the execution of final judgment that is not successfully made. That's the decision. So there must be. It's not only the decision itself. There must be another step of executing the decision. So the same in Indonesia. Even though the arbitration decision has been final and binding, we cannot just bring that as a reason to file for a petition. According to Article 195 of Indonesian law procedure, we must execute it first. So after failing executing them, then it becomes go to the requirements of final and binding. So without that, the judge will say that there's premature of petition. Okay. How is the international arbitration decision to if the debtor has been declared bankrupt and there is arbitration decision, how could we proceed there? Yeah, in the process of bankruptcy proceeding, the management of the bankruptcy estate, there are two ways of how to execute the decision. First is if the party can obey them voluntarily, meaning that if the receiver can accept the decision of international arbitration, it doesn't have to be to start through the execution anymore. Yeah, they can just file, they can just register that to the receiver. All right. So, but if the receiver rejects that, then they can go through the execution process. So we have Article 29 in our bankruptcy law stating that when the debtor is declared bankrupt and there is still other ongoing cases, including, for example, the arbitration, domestic or internationally, then all the case must go. And what they do, as Sadan said, they can just go to register them to the receiver. And according to Article 26 and 27 of Indonesian Civil Bankruptcy, that's the last one is we have now. We have now. Okay, but I will ask that after this as a question to you. But that's my response for this time. Thank you.
So if I can just take it in two parts. The first one being an arbitration award as evidence to wind up petition, and the second one being arbitration award as an evidence of a claim in the liquidation. Two different things. So for the first one, the concept is the same, but the wordings are different. Over here, I appreciate it's called an execution executor. Yeah. Because Singapore is a common law jurisdiction, the term we use is registration. Registration. Yeah. So when you have an arbitration award, it is final and binding. Under Singapore law, the only way to challenge it is by setting it aside in the Singapore courts. The good thing is that you only have 3 months from the date of the award to set it aside. So as a matter of tactic, if I have won the arbitration, what I do is I wait until this 3 months is over, and then I go to court to register it. That registration process generally is a simple one. The effect of registration is that the award is now deemed a judgment of the Singapore court. And once it becomes a judgment of the Singapore court, you can then enforce it like a Singapore court order. So after 3 months has passed, you registered it, you have a Singapore court order that recognizes it, and then after that you can use that to commence winding up proceedings. Yeah, so a bit similar. But just to add one more thing, outside of commencing winding up proceedings, the Singapore court also has other things you can do. So for example, if you have a court order, you can apply for this thing called examination of judgment letter, which is very powerful. What it means is that you write to the director of the company, and he is compelled to disclose the assets of the company in Singapore and overseas. So this is something very unique. I know the concept of enforcement in Indonesia is a bit different. You'll have to go to that specific court in that specific province where there is an asset, and you must show evidence that the assets are there. In Singapore, you can compel the party to disclose the assets, and I mean bank account statements, apartment buildings, everything. It's like, yes, it's like a subpoena. And then you can use that to slowly start enforcing. And why you want to do this is because when the company goes into liquidation, everyone is doing pari passu. But if you can find a bank account that has enough money, you can file an application to take the money from the bank account. So there's something else to keep in mind. Now, to move on to the next step, which is that the company is already in liquidation, I have an arbitration award. What do I do? In this situation, the practical way would be to go to the liquidator straight, submit your proof of debt, and then have the liquidator admit it. In most cases, the liquidator will admit that. And because the liquidator is appointed by the court and is somewhat viewed as an officer of the court, he or she has the authority to admit that debt. And why usually we do that is because at that point in time, it becomes a bit of a waste of time and money to go to court to register it. And all that matters is that the liquidator, who has now stepped into the shoe of the directors, recognizes and admits the debt. So the advantage of working with people like myself is that we have very good relationships with the liquidators. So usually, before we file a proof of debt, we'll pick up the phone, have a cup of coffee, tell them what we're going to do, be on the same page, so that it's smooth sailing from there. But of course, because company is in liquidation, you will get paid cents of the dollar because it's a pari passu payment.
Alright. Thank you, Adnan. Is it clear, Bob, or you need further information? Thank you so much. Very new and fresh from you. And can we also drop that point back to disclose the assets from the debtor? So jadi nggak capek itu, nggak panjang ya. Alright, second question maybe from the first. Oh, another one from Bang Rik again. To Adnan back. Okay, again with you.
Yeah, but you have article 186 of INSOLVENCY, yeah, Insolvency and Restructuring Dissolution Act, right? So article 186 of INSOLVENCY states that the insolvent, the debtor that has been declared bankrupt or insolvent in Indonesia, it has been winding up in your regime, could be terminated or could be stopped. The status of winding up company could be stopped if at the final of the liquidation, it can prove that all of the debt has been paid. Yeah. So I think you have rehabilitation, and that's one of the reform of your law from the previous one. Because I read in one of the articles in your in Singapore law that before your High Court have still problem with that, even though it has been started in England and Australia. But now you have them, you confirm them, yeah, in Article 187 of IRDA, as a part of you to say as an insolvency harm. So how is that now, the article in the process? Have you put that in practice? Because we have now, this is now being a question in our position. We have Article 215 now. We call that rehabilitation, but everybody say that that's for personal. But I have seen them in your regime. Thank you.
Section 186, very rarely have I seen it invoked. From my understanding, it has to be in a situation of course when there is a surplus of assets to be able to pay the liabilities, which means that the company is solvent. From my experience, this could likely happen only in a situation, I suppose, where there is some contingent receivable of the company, which comes in subsequently. Of course, there are a few ways that we can sort of approach this. The first way is the company is cash flow insolvent. Maybe 18 months down the road, it will receive a large sum of money. A good example would be right now, if you are a creditor of FTX, you will get back 170% return. So in that kind of a situation. So instead of putting a company into liquidation, what we could do is put the company into judicial management. And the regime difference here is that the company can carry on as a going concern. Then when the money comes in, people are paid, we then remove that judicial management. If the company is in liquidation and suddenly gets a windfall, then I would agree with you. You can make the application to court, and everyone gets paid back in full, and then you reinstate the management. Why we see it so rarely, I think it's because of the nature of businesses in Singapore. Singapore is a small island. A lot of the times when we do have cross-border businesses, Singapore is at most a holding company. So what this means is that usually by the time a company has become insolvent, there is fundamentally no possibility of there being any kind of recovery. So while Section 186 is there, I have rarely seen it applied. I would think potentially it may apply to a cryptocurrency company, where suddenly it has got a certain amount of assets that have gone up. You cash it out, you have enough money already. But outside of that, a traditional brick and mortar business, I don't think so. Because you will never be in a situation where you can sell the asset of the company at a premium when the company is already in liquidation. It will be a fire sale, it will be a distress sale, and that's how people will put the pressure on them. But I agree, theoretically, it is possible. Of course, there is another way, which is you get a white knight investor. The investor says, okay, I will put in this money to rehabilitate the company to reinstate the directors. But usually in that situation, it is done where the directors have done some hanky-panky and they don't want to get exposed. And so I would think that even if it's in that situation where the director comes and says, I will put in the money to pay everyone back, I don't know if the court will allow it. If it means that the director can, in inverted comma, buy his way out of his future director's duties. So that will be my interpretation of section 186. Thank you so much.
But Ricardo, just to add a little bit, I promise I will give you the name of the company, but I cannot remember it right now. So there is a loophole that this has always been our discussion, right, about the end of the bankruptcy if all the creditors have been paid in full, whether they should be liquidated or they can be rehabilitated. So the way this company, what the company did was, so investors coming in, so every creditors has been satisfied. So Article 202 in conjunction with 215 has been fully satisfied, and then they applied the revocation of bankruptcy status to the court has been given, but they do not proceed to follow up with the rehabilitation to the newspapers. They just carry on forward. Yeah. So as long as you don't revoke your NPWP and you do not revoke your status in the Menkumham, yeah. So now the new shareholders is in place. They carry on. They try to pay the next, and everything is going as well. So now the company is alive, more alive than before because now it's very healthy. No more bankruptcy status. Everyone is happy. No need to go to 3 days debate on whether we should liquidate or rehabilitate. And now they are carrying forward. I will give you the name of the company. I can remember it right now. But I think it's more like a loophole today, rather than go to liquidation or rehabilitation. I think this because I think, ma'am, up to this day we are speaking right now, there is no what do you say, an online or a live connection between Kemenkumham and bankruptcy court, and so if something happens in the commercial court, does not necessarily put the info forward to the Kemenkumham. Yeah, that's the loophole. Until you fix that, I think you can still use this as a loophole in the. Well, the point is to revive the company, right? It's not to create more loss to creditors. No, the point is if you have paid the debt in full, then why should you be dead, right? If you are a natural person, if you are a person, a private person, of course you cannot be killed, right? So that's why there's a rehabilitation. But I think the bankruptcy law does not say that you have to be a person in order to have the rehabilitation, because it says entity. So it can be a company or a person. I think it's the same. Okay.
All right, thank you. Your additional explanation, Bang. Okay, Bapak Ibu, I have got a question. Ada yang mau tanya langsung mungkin? Oh, okay, on the right side. Yes, please tell your name, maybe from where you come from, and then what is the question.
Okay, thanks to all speakers for very good explanation and good presentation. My name is Yuda, API 28. I have several questions to all speakers. Question number one is about the foreign arbitral law. Is it enough the foreign arbitral law for basis to register the receivables application to Kurator, or we need to get the putusan ex quater first? That's question number one. And then second is about the foreign court decision. As we know, if the answer number one, we need to get the putusan ex quater for arbitration award. How about the foreign court decision? And then the third question is, what is your opinion if in bankruptcy proceedings, in bankruptcy process, the Kurator finds out that the debtor has assets in a foreign country, let's say Singapore. So will you pursue that asset? And then how to pursue it? And maybe this is a question for Mr. Armando.
Practical question.
Yes, practical question.
Cakep.
Yeah, question for Mr. Armando. Yeah. If the curator decide to file a lawsuit in Singaporean court or in SIAC, in arbitration, will the Singapore court recognize the legal standing of curator based on Indonesian court decision? That's the question. Thank you.
Thank you so much. Can we give applause to Thank you so much, Angkatan 28 keren nih. Okay, the first question regarding the executor procedure for the arbitration award. Nah, nomor 1 ya. Kayaknya mungkin yang cocok jawab tuh Bang Sahat sih dalam lawyer in the morning, musician in the night. Alright.
My God, it's like a paper exam again. Okay, thank you very much for the question. Yeah. Well, actually, like as before, well, actually, like from the presentation itself, and also like from the things that Mr. Edu or Mr. Shep, and also just mentioned, yes, we need to get that. Actually, I mean, like if we go through the process, for example, for the executor. Well, I mean, like I only can mention for the foreign arbitral award. Well, as for the foreign court decision, I don't know. From some of us in here, we just like to talk about that. Actually, I think like there will be a fight for that. But like for the foreign, because like there's no basis for that. But like for the foreign arbitral awards, yes, we need to get them as a decision. Well, I mean, this is like the thing that also already mentioned in the Article 65 until 69 from the Indonesian arbitration law. It's also already mentioned for that from the Article 6, as mentioned before in my presentation. I also already did mention for that. So maybe like this is like a thing that I can share right now on. And then I think like the other than that for the foreign company and also like for the foreign court decision, I think like the gentleman on the next slide, I think like he can bring something and like that and ask for that. Thanks.
Thank you Bang Sahat. Nanti kalau kurang jelas bisa tanya langsung jawab lagi ya Bang ya. Alright. The second question regarding the enforcement of the foreign court decision. If the arbitration award required expedited process, how about the foreign court decision? I think Dr. Shahdan, everyone's mentor, would like to also answer it.
I'll try to explain. I think that this is on a theoretical level. Yeah, I cannot say that it's been done, or I don't know if anyone has ever succeeded in doing so. But consistent to my previous sharing, either as your mentor before your API exam or as your one of the lecturer in the API education program. Once you are a receiver, the Thor's hammer is in your hand. You know the Thor's hammer, right? You can do anything. You can build, you can destroy anything. See? Let's forget foreign court decision. Let's get a more realistic example. A claim from the bank, right? Doesn't get any more real than that, right? The bank has a computerized system. I think the chance of them being wrong in filing the claim is like 0 to minus, right? And they are being supervised by the OJK. So the chance of the claim filed by the bank is 0 to negative. Okay. Have you seen a claim filed by a bank being rejected by a receiver? Yes, I have seen that. So forget foreign court decision. If you are the receiver, the Thor's hammer is on you. So if a creditor filed a foreign court decision, not being litigated in Indonesia, not being acknowledged by Indonesian court, if you are as the receiver has this, I can say, level of knowledge or a level, a broadness of a attention to the case, which free from the interest on defending the debtor or the creditor, if you are really neutral, I think there are so many things beneath the sky that you can do. For example, if the foreign court decision is coming from Singapore, for example, you can ask or you can appoint a Singapore lawyer to give advice whether this decision is valid and whether the court really happened, or if the decision is like this and that and what should be done. And the cost of such appointment can be burden to the bankruptcy estate. So if you have this kind of attention, I must say, to the bankruptcy case that you are currently handling, and you are free from the interest of defending either the debtor or the creditor, there are so many things that can be done to a foreign court decision, right? So I cannot say that you should reject or you should accept, because of course one thing that we could agree upon, that there are so many things that should be done beforehand, before you say that foreign court is acknowledged or not. There are so many that you should be doing first. But the point is, it's not as simple as, oh, foreign court, no, Indonesian court, yes, it's not as simple as that. So the Thor's hammer is in your hand. You should remember. So the 2 weeks of education of ACPI that you've been done is not as simple as ABC, or now you are a receiver. No, it's your responsibility is far more than that. You should understand this. That's why being a curator receiver is not a simple job. Many things are in your hand, many lives fate are in your hands. So can you imagine the litigation that has been done to that decision for on a foreign land? They might have appointed a very expensive lawyer, probably I don't know, the lengthy process of a trial, and then it all comes down to you whether you accept it or not. Can you imagine what kind of responsibility that falls in your hand at that time? So the answer to you is on foreign court decision, if you are the receiver and the bankruptcy case is ongoing. I've given you one example on what to do, but the answer is not as simple as accept it or not. There are so many things to be done. You want to add something?
I have a follow-up question on that.
I'm not asked to.
Yeah.
All right, that's very interesting.
Let's say that there is a Singapore court order, right? I have given advice to the receiver that, oh, this looks correct under Singapore law. If the receiver admits that debt without making this creditor go through Indonesian civil procedure to get it executed properly, does that open the receiver up to a challenge from another creditor?
Yes.
Either whether commercially, financially, or even ethically?
Any other creditors who wishes to challenge the receiver's decision can file, we say, the other so to challenge either the list of creditors of the amount of claim that has been declared by the receiver. So if, for example, siapa tadi Pak namanya? Let's say Yuda as a curator, as a receiver, admitted to that, and probably the other creditors in the room say, oh, it's a foreign decision, you have to do this, that, and you can challenge that easily. So, Adnan's question made a very good point. Your decision is not final anyway. So make sure if once you admit it or reject it, you have very good grounds on why you did that, why you did that decision. And you can be challenged either it's not final.
All right, thank you so much. That's pretty clear, Adnan? Or you would like to have a general discussion? All right. The next question is to you, Adnan, but I think let's say it from the last ending, because another question arises is regarding the tips and tricks. How the receiver can tracking, can seize the asset outside. So Yuda has a question to each of the speakers, maybe shares 1 and 2 tips, the $1 million tips to us, Bang Daniel, Bang Shannon, and also Bang Sahat. Okay? the tips and the tricks how the regime could seizure, could tracking the asset outside. Yes. Jangan jadi baris ini dong Bang ya. Tips dan triknya caranya Bang.
Okay, nice.
Yes, you at least you have to track and to seize, confiscate the asset of the debtor outside of Indonesia. Kalau ini all aset nih Bang, gimana caranya tahu dia dapat data aset di Singapura, terus gimana how to seize that?
Well, I think that the basic principle is to do your administration duties. You check on all the documents, the company documents, and all the transaction ledger and everything. Then to check on whether there's been I don't know, assets acquirements outside Indonesia or even transfer of funds. And then you contact the SPVs. I think nowadays it's easy to communicate and coordinate with legal consultants in each jurisdiction, because they know how to proceed. So I think that for example, we had this experience before. We in Singapore, of course, in Singapore because there's a lot of cases involving Indonesia and Singapore. What we did was we actually contacted the Singaporean lawyer and also PI, and also private investigator to check on the to follow up on assets and to check, and especially that we found that in other countries, for example Singapore, is a bit easier check on a company or personal assets. So that's what we do. So it's basically administrative work and religious, and then communication.
Okay, nice. Administrative due procedure is a must. Thank you so much. Bang Sahab, you want to add? Kisi-kisi? Oh, already some of everything. Pretty clear, Pak?
Sorry, my last question is to Mr. Ratan.
Yes.
If the curator decide in order to pursue or hunting the asset in Singapore,
Yeah.
if the curator decide to file a lawsuit to
Yes,
Singapore court
yeah.
decision,
Yes.
will Singaporean court recognize the legal standing of the curator?
I feel like I'm rehearsing for a potential case here. That's how I'm feeling right now. Just to wrap up on the earlier answer, Singapore does have a much easier platform to do searches. So if you have someone's name, you can do a search to see whether he or she is a director or a shareholder of companies. You can also do searches to see whether they own any property. So what we do is we'll ask for the person's name, the person's wife's name, their children's name, and do the searches from them so that we know the respective pressure points, which will always be the due diligence we do before we think about commencing proceedings. Now, there is no issue with an Indonesian curator administrator commencing proceedings in Singapore on behalf of the company that is in bankruptcy. What I would ask for would be an Indonesian law opinion from an independent lawyer who will confirm that under Indonesian law, these are the requirements for the appointment of the curator. The appointment of this curator has been done in accordance with Indonesian law. It is valid. Under Indonesian law, the curator has the authority to commence proceedings on behalf of the state, and so therefore he has authority to do so. If I can get my hands on that, we can then commence proceedings. I have that in my hand as insurance, as a safety net. Because the Singapore court is not going to ask me for this, but I'm quite sure that the person that's suing is going to ask for that. So if I had that in my hand, it will be reactive. So we'll be ready. We have the authority, everything. So whatever you need to do here, POA, creditors approval, whatever you need, we get it done and we get an independent opinion. So it cannot be the curator's own lawyer. It has to be a third party independent Indonesian lawyer who can give this opinion, right? And I can appreciate that this opinion can also take into account the uniqueness of each province, because I'm sure that there might be different regulations there. The tricky thing that you must keep in mind is this. First and foremost, when a foreign party sues a local company, the local company can ask for this thing called securities for cost. I'm not too sure if there's a similar concept in Indonesia, but what this means is that I am being sued by a foreign entity. I don't know if this foreign entity has any assets in Singapore, so I'm going to file an application for you to put money into the Singapore courts to cover my cost. You give security for my cost in the event that I win. Because if I win and you are overseas, I cannot then go after you for the cost. So now here, there is two levels. Number one, it is a foreign company. Number two, it is a foreign company that is bankrupt. So in this other situation, if I was on the other side, if you comment something against my client, the very first thing I would do is file a security for cost application. I'll say it's a foreign company and also it's bankrupt. I'll also say the claim is not good and everything. And so I want the curator to put whatever it is, 100,000, 200,000 into the Singapore courts. And then if you don't comply with that, I'll get the claim kicked out. So whenever we are dealing with a situation with a foreign entity, we always let them know, be ready to give this money, because they will always ask for that. So to summarize, yes, provided under Indonesian law, you have the authority to do so, you can commence proceedings, but just be ready for what the other side will throw at you, which will be all kinds of procedural, speed bumps in order to slow you down.
Okay, very excellent, straightforward answer. Thank you. Pak Yudi, cakep dong ya? Cakep. Alright, there is two questions. I think we still have time. Oh, okay. Langsung super set. Ya baik Pak. Silakan Bang Ricardo. Boleh dong Bang? Boleh berhenti mungkin? Oke. Pertanyaan ke Akan ya Bang? Bang Syahdan atau Bang Sahat? Bang Sahat.
Banyak kampanye yang kemarin. Yeah, Sahat. If I can address that in Indonesia ya, dalam bahasa Indonesia. Jadi tadi kan dikatakan bahwa kalau putusan arbitrase asing, gitu ya, itu kan untuk melakukan eksekusi kan kita butuh eksekuator. Eksekuator itu hanya akan diperlukan ketika pihak yang kalah tidak melaksanakan putusan, gitu loh. Jadi kalau ketika seorang debitur dinyatakan bangkrut, gitu, itu akan tergantung pada kuratornya. Tidak perlu eksekuator. Jadi international decision itu tinggal daftar pada itu kurator. Kalau kurator menolak, nanti masuk ke ke hakim pemutus untuk memutuskan apakah itu akan eksekutif atau tidak. Karena apa? Karena kalau debiturnya udah bankrupt, lalu kemudian perusahaan asing harus masuk melalui pengadilan negeri untuk minta eksekuator, dia itu sudah menyalahi proses sentralisasi penanganan filing, gitu ya. Jadi kecuali kalau kuratornya menolak, maka dia akan naik ke majelis pemutus. Jadi tidak dibutuhkan eksekuator dalam pelaksanaan itu. Kalau saya nggak salah tangkap tadi dari penjelasan tadi ya, gitu. Itu nanti mungkin kita bisa diskusikan. To Pak Anam again, I think I'm very happy to hear your explanation regarding the question of can Indonesian receiver bring the case to the in Singapore court? Yeah, I think I can agree with that. If I can see from we can refer to the case of HC Simanjuntak, if I'm not mistaken. That's the case, right? Yeah, Paul Thanos. Yeah. So that's personal. And Singaporean law, at the time examining the case, is not based on the UC trial because that's private, but they based it on common law. So as far as it can be proved that the decision has been final and conclusive, so they will respond for that positively. And we see that in the case of Garuda, the personal standing in judicial of the Indonesian receiver is based on the UC trial. So Singapore is very active now to expand the area of litigation process. As you say that Singapore is one of the hub, and accepting the foreign litigation through the UC trial. So this two consideration, I think, is very new for us, and we are still trying to get better understanding because in our system now, we don't have this. Okay.
Alright, thank you so much. Oke, Bang aku juga mau tanya Bang. Oke. Gak boleh ke Bang Daniel ya, gak boleh. Nanti Choi. Yeah, you can ask to them. Okay, please, Committee.
Ya, kalau kayak Edo ya apa aja. Oke, saya mau nanya ke SMS. Oke, apakah semua putusan arbitrase bisa dieksekusi, dimintakan eksekusinya di pengadilan di Indonesia? Apabila putusan arbitrase itu bukan dari negara New York Convention, dan apabila tidak bisa, apakah ada cara lain untuk mengeksekusinya? Saya boleh nanya lagi ke Akan?
Of course, Bang, boleh dong.
In Napayo case, the satellite company, they won through ICC, I believe, right, in Singapore. But they try to execute Indonesian embassy assets in France, in Paris, right? But some people see that is against the Geneva Convention on Diplomatic Protection. Seeing that the decision was made in ICC in Singapore, do you have any views maybe why they do not try to execute the Indonesian embassy or Indonesian assets in Singapore? Right? That would be much more sufficient, and I think that would be much more easier, right? But why they don't do that? Maybe you have a view on that. And my second question is that we know that we have a recognition procedure for a composition plan. Do you have similar things like recognition for bankruptcy decision? And if you do, whether that can bypass the lawsuit, any lawsuit, like, you know, whether you require security payment for that, like if you have a decision and you have a recognition, would that be a better route to take? Okay, thank you.
Alright. I think the first question will be answered by SMS. Langsung Bang ya, not you, by SMS jawabnya. Oke.
Jadi bukan saya. Okay, thank you. Abang Dr. Ricardo, I would agree more with your statement before. For this thing, maybe later Bang Ricardo izin untuk the discussion to further related with the executor. So, Bang, SMS ya gitu. So, as I understand, Bang Alamo, for my presentation, we know that Indonesia also identified the New York Convention, which is like addressed by some members was already ratified in there. So from my perspective and like from my understanding, definitely like the one that I mean like if like you want to put that forward and like the one that already been also acknowledged in Indonesia is also like only the member in there. But yeah, again, another tricky question. How about outside the New York Convention? Well, I don't know, I've never done this part before, but maybe if I put research and theoretically, yeah, I must say that that's what our positive law mentioned. So outside that, there will be another process, for example, maybe in our court there. This is like the kind of thing that we can do. This is like a perspective that I can understand right now. That's my answer for that. Thanks.
That's very interesting point. Another
So for the two questions, first and foremost, this is my speculation because I'm not the lawyer on the case, although I do know the lawyer on the case and people that are involved. First and foremost, if they did not go to Singapore, it must mean that it should mean that they were somewhat concerned about diplomatic immunity in Singapore. Because the law in Singapore is somewhat clear. And if I remember correctly, it was the Ministry of Defense that was the respondent, so which is fundamentally an organ of the Indonesian government. On this topic, I have seen cases where attempts are made to enforce against a company in Singapore that is viewed as an extension of that organ. And they may then allow that because we did not subject to that immunity. So the first one is I think they were concerned about the merits. And the second one is if it were me, I would not feel confident on the Singapore courts granting an order against the Indonesian embassy, given the relationship the two countries have. It will be very, very sensitive. I think the last thing we want is to, I don't know, put a seizure on the Indonesian embassy in Singapore, which is thankfully no. Yeah, that's the last thing. And so I can appreciate maybe France may just have a different civil procedure, or at the very least, the French lawyers are confident that they could make the kind of enforcement done. So that's my view on this one. They should be concerned with the merits and concerned about the policy behind it. Now the next one is recognition of bankruptcy orders in Singapore. If I'm not mistaken, the case of Mr. Paul Thanos was one where the Singapore High Court recognized the bankruptcy order. And there were a few reasons why the Singapore court did that, but if I remember correctly, it was because Mr. Thanos had submitted himself to the jurisdiction of the Indonesian bankruptcy court. He was not able to show that the decision was not final and binding, and he was unable to show that there was a breach of natural justice. So, if I recall correctly, I think he did make some arguments, or he tried to make some arguments that, maybe there was some fraud or things like that. But the Singapore court did not seem convinced by that. And actually, on this topic, even in the application for Garuda's recognition, Gray had argued that they didn't get due process in the PTU proceedings. I think they argued that, we asked for some documents, we didn't get it, we weren't allowed to vote. And the Singapore court said that you should not use Singapore as a second bite of the cherry. And you cannot impose onto Indonesia what is Singapore's insolvency regime. Because I think they said that they were not allowed to vote, they would vote in the same class, but that is not the law in Singapore. So, to summarize, the Singapore courts, in my opinion, would be very slow to go behind the decision of the Indonesian court, or for any other foreign court, for that matter, unless if the evidence is black and white. But anything below that, I don't think that will be feasible. Yes, if there is bankruptcy proceedings here, you can get the order recognized in Singapore, I think under our Singapore constitutional model on insolvency law. And then the Indonesian curator can exercise the powers
that are available in the Singapore regime. I think it's definitely something that can be done. And we may see a lot more because there is a lot of Indonesian money in Singapore.
Okay, just a little follow-up on that. So, can you explain a bit more about the recognition procedure? Is it more like a application, like administrative, or is it like a court proceedings where the parties have to, prove and everything, like a regular lawsuit?
It will be a full-blown court proceedings. The only thing that there might not be is there might not be an evidential hearing. So it would be what we call originating application, where parties file their affidavits. So the receiver will file to say that this is the bankruptcy order, this is what has happened in Indonesia, I've done my searches, this person has ABC assets here, the decision is final and binding, he has not appealed against it, and so therefore we should enforce it. And then the person that is being made bankrupt will have to counter argument that no, it's not final and binding, or there's been a breach of natural justice, there's a public policy reason why Singapore will not recognize it. So it will not be administrative. A bit different from when you register arbitration award. That application is somewhat administrative, but for this, it will likely become a full-blown hearing.
Is it the same with composition plan recognition? Like for PKP?
Yeah, it would be the same. It would be substantively it would be similar because the same arguments would be run.
So it would be a single party coming to the court saying that we have this decision composition plan, so please recognize it.
Yeah.
So every Singaporean should also recognize it.
Yeah, correct. So they will make the argument that we have satisfied the requirements under the central law on insolvency, and therefore should be recognized. And whichever unhappy creditor there is in Indonesia can go there and argue to say why it should not be recognized. I might be a bit out of line to say this, but this is my own personal opinion. I can't really, so don't put it against the country. Given that Singapore wants to be pro-insolvency, wants to be insolvency hub, I think generally, as long as there is no clear evidence of some wrongdoing, it will most likely accept and recognize foreign bankruptcy, foreign proceedings, and Indonesian composition plan. It wants to do so, unless it is something very clear why it cannot do so. So, for example, maybe if it is a recomposition plan of a casino gambling, it's against Singapore public policy to recognize gambling, even though we have Marina Bay Sands. But anything beyond that level, I think should be okay.
Alright, thank you so much, Adnan, for your explanation and Bang for your question. So, ladies and gentlemen, today's discussion has given us not only perspective but also practical solution from the speakers. From the Mr. Daniel Alfredo, remind us that jurisdiction friction between the happy with arbitration, emphasizing the lack of the certainty, and that's the duties of the receiver also to understand from the beginning the basic foundation of the arbitration and insolvency itself. Dr. Sansi Dabugen expanded the role of arbitrators as the evidence in insolvency, highlighting their admissibility, limits, and the importance of understanding the ex-creditor in enforcement. In addition to that, Mr. Shannon brought the conversation to the core of the receiver authority, power, and illustrating how the legal standing should post the bankruptcy and what it means for represent insolvent party is ongoing or future arbitration. The last but not the least, finally, Mr. Adnan give us a very practical solution, do and don'ts, what kind of a Singapore laws views on our Indonesian proceeding court. Can we give a biggest applause to our exceptional speakers today? We really appreciate that insightful presentation, and then together this insight underscore a common message for us that ACPI practitioners must be both locally grounded but internationally aware. And thank you again to our speaker and our participants. Please, this manner is more than just an academic discussion. It's a part of JLA ongoing effort to ensure that ACPI AKPI remains not just relevant, but resilient and future-facing. Because JRM, we believe in this, AKPI for all, and all for AKPI. Thank you so much. Kayaknya tidak lengkap kalau misalnya, kalau from this discussion, today's discussion, kayak penting banget untuk nanti ada further discussion, vocal group discussion, juga kita bisa fokus group, yang ditutup dengan vocal group discussion. Biar nantinya juga bisa berkembang mulai dari bank zaman JRE lagi, sehingga bisa kasih kontribusi yang juga bagus. Biar ada partner diskusi yang sepadan gitu buat Bang Ricardo. Ada bang aku. Kayaknya tempat kosong kau hari lagi. Siap. Oke. Mungkin kita bisa undang mungkin perwakilan dari calon ketua umum dan juga sekjen, juga ketua harian kira-kira things that we like JRE do for the upcoming that relevant to also the idea of this seminar in this forum. Apa aja sih Bang dari JRE, program-program dan mungkin lanjutannya. Terima kasih. Tepuk tangan dong sekali lagi dong dari JRE dan AKPI member. Thank you so much.
Ya, dari JRE tentu kami melihatnya hal yang kita dapatkan hari ini itu sangat menarik ya. Banyak insight yang kita bisa dapat ini dari 4 speaker yang luar biasa, dan dari view-nya Adnan dari Singapore Law tentu itu juga memberikan insight baru buat kita gitu ya. Dari perspektif kami bahwa JRE ketika memang akan diberikan amanat untuk membawa AKPI ke depan, tentu seminar, diskusi, ya forum-forum seperti ini akan menjadi salah satu hal yang kita utamakan gitu ya. Brother Reza dan Brother Edo, dan tentu itu sudah kita lakukan Nancy di periode saya sebelumnya. Dan tadi saya melihat ada beberapa hal yang penting. Salah satunya adalah bagaimana menerjemahkan prakteknya putusan arbitrase di dalam praktek implementasi praktek PKP atau pilot, supaya jangan multitafsir, kira-kira begitu. Terus tadi juga tentang bagaimana menerjemahkan, bagaimana meletakkan rehabilitasi, kira-kira gitu. Jadi beberapa hal dari seminar ini poin penting yang mungkin bisa kita elaborasi, Nancy, dan juga kita jadikan satu kajian dan kertas kerja yang akan didorong oleh AKPI untuk memperlengkapi dan memperbarui Undang-Undang 37 2004. Tentu semua bisa kami lakukan kalau memang teman-teman dan anggota AKPI memberikan amanah kepada Jimmy Reza Edo untuk membawa AKPI ke depan. Terima kasih. Pertama dari Reza. Terima kasih.
Thank you so much Bang Jimmy dan Bang Reza. Let's continue to build bridges not just across north but across borders. Now we turn to decision to our MC. Thank you so much.
Thank you, Ms. Nancy, for leading such an insightful seminars. Ada tag yang sangat keren dari Nancy tadi. Kurator AKPI harus locally grounded, but internationally aware. Semoga untuk pembicara dan moderator kita. Before we end up this session, we would like to take this moment to express our gratitude to our speakers and moderators. Please come to the front stage. May I? Yeah. Yes. May I invite Bapak Ricardo Simanjuntak to kindly present a gift to our esteemed speakers, Mr. Daniel Alfredo. for next, I'll invite Bapak Andreas Tanggar. Please come to carry present to give to Mr. Sahab Sidamri. Ya, terima kasih Bapak Andreas Tanggar for our third speaker and also my mentor. Terima kasih mentor tertulis saya juga. I will invite please Bapak Fadli Nasution to kindly present his gift to our third speaker, Bapak Andreas Tanggar. Terima kasih Pak Fadli. And for our last speaker, I would like to invite Bapak Jimmy Simanjuntak sebagai calon ketua umum dari Jimmy Resa Indonesia. Terima kasih Pak Jimmy. And for the last but not least, to our beautiful moderators, I'll invite Bapak Reza to get the present to give to Mrs. Nancy. Supaya barang-barang dan terlihat penuh dan ramai, mungkin kami juga mengundang seluruh peserta untuk maju ke depan untuk foto bersama. Untuk teman-teman yang masih di luar, rekan-rekan yang masih di luar bisa masuk terlebih dahulu untuk foto bersama. Yang merasa muda boleh duduk di depan. Oke.
Udah itu marah. Mau marah. Udah di foto. masih ambil. Matiin aja. Bener loh. Kita dapat semuanya loh. Gitu.
Baru teman-teman api for all for api.